The Hobbs farm sat on 400 acres of red clay and rolling hills, land that had belonged to the same family since 1911. Walter Hobbs was 81, and he had buried his wife, his father, and 2 brothers on that land. He still woke at 5 every morning to feed the chickens, even though his hand shook now, even though his knees ached with every step down the porch stairs. His granddaughter, Elena Hobbs, was 32. She had grown up in the city, but every summer of her childhood had been spent on that farm, chasing fireflies past the old barn, learning to drive a tractor before she learned to drive a car. She was a corporate attorney now, sharp, exacting, the kind of lawyer who read contracts twice and then read the footnotes a third time. She worked 80-hour weeks at a firm in the city and hadn't visited the farm in almost a year. That changed on a Tuesday in March, when her grandfather called her, his voice tight in a way she had never heard before. "Elena," he said, "there's men here. They say they're buying the land. They say I don't have a choice." She drove 3 hours that night without stopping. The company was called Faro Vance Energy, a mining and pipeline conglomerate worth $11 billion, with lawyers on retainer in every state capital and a public relations department that had spent a decade rebranding itself as an environmental partner to the communities it operated in. Faro Vance had discovered a rich vein of lithium beneath the county, running directly under the Hobbs land and 6 neighboring properties, and they intended to extract it. Their method was simple. First came the smiling representative, a man named Desmond Cray, who arrived at Walter's door with a folder full of paperwork and a check that Walter did not know how to properly value. When Walter said no, the tone changed. Cray began speaking about eminent domain, about public utility easements, about the county's economic development board, about how much easier this would go if Walter simply signed now rather than later, after the courts get involved. Elena arrived to find her grandfather sitting at the kitchen table with a stack of documents he had not signed, his hands trembling, not from age but from fear. She read every page that night, and she found the first lie. That was illegal, but it wasn't enough. Companies like Faro Vance had lawyers whose entire job was to make illegal things disappear before they reached a courtroom, to settle, to bury, to outlast a family with more money than that family would ever see in 10 lifetimes. Elena knew that suing them directly, on ordinary grounds, would take years and money her grandfather did not have. Faro Vance was betting on exactly that. They always did. She needed something else. Something they hadn't planned for. Elena spent the next 11 nights in the state archive, going back through the deed history of the Hobbs land, back past her grandfather, past his father, back to 1911, when the land was first homesteaded under a state agricultural preservation statute that predated modern eminent domain law by almost 40 years. Buried in that original 1911 grant was a clause almost no living attorney in the state had ever had reason to invoke, a mineral rights reversion clause. It stated that any mineral extraction beneath land granted under the original Agricultural Homestead Act required the homesteading family's mineral rights to be independently purchased, in a separate transaction, at fair market value determined by a jury, not simply absorbed into a surface land seizure. It had been written to protect early homesteading families from exactly the kind of land grab railroads had once used against farmers a century earlier. Elena had found the crack in the foundation. She did not go to Faro Vance with threats. She went to them with silence. She quietly filed a motion asserting the Hobbs family's separate mineral rights under the 1911 statute, a filing so narrow and obscure that Faro Vance's legal team, confident in their eminent domain strategy, barely reviewed it. They proceeded exactly as she hoped they would. They began preliminary drilling surveys on the property, believing their eminent domain paperwork, fraudulent as it was, gave them the right to do so. Every single survey they conducted, every truck that crossed onto Hobbs' land, every core sample they drilled, was now a documented act of mineral trespass under a valid, still enforceable 1911 clause that had never been repealed. Elena had photographs. She had time-stamped surveyor logs obtained through public records requests. She had the county clerk's written confirmation that no public utility designation had ever existed. She let them keep drilling for 6 weeks. When Elena finally filed suit, it was not against Pharaoh Vance's eminent domain claim at all. She let that claim collapse on its own once the county confirmed, on record, that no such designation had ever been approved, a fact that alone opened Pharaoh Vance to a fraud investigation from the state attorney general. Instead, her suit was for mineral trespass, filed on behalf of Walter Hobbs and, once word spread, 5 neighboring families whose land sat over the same lithium vein and who had received the exact same fraudulent paperwork from the exact same company. Elena had spent her nights not just in the archive, but knocking on the doors of neighbors Pharaoh Vance had already intimidated into silence. Pharaoh Vance's own surveys, the ones their team had confidently conducted for 6 weeks, had already estimated the lithium deposit's value at just over $400 million. Pharaoh Vance sent their top litigator, a man named Arthur Pell, who had never lost a case against an individual landowner in 18 years. He walked into the courtroom expecting a farmer's granddaughter with more anger than legal standing. Elena did not raise her voice once during the entire trial. She simply presented documents. The forged utility designation, the surveyor logs, the county clerk's sworn statement, the 1911 statute itself, still valid, still binding, cross-referenced with case law from 3 prior small disputes in the 1950s that had upheld it. She called Desmond Cray to the stand and asked him, calmly, whether he had informed Walter Hobbs that no public utility designation existed at the time he presented the paperwork. Cray, under oath, could not lie his way out of it. The willful bad faith finding came on the 2nd week. Treble damages were awarded. The final judgment, combined across all 6 affected families, came to just over $1.1 billion. Pharaoh Vance's insurance did not cover intentional fraud. Their stock dropped 40% in 2 days. 2 board members resigned within the month. The state attorney general opened a criminal fraud inquiry into the falsified county documents, and Desmond Cray, facing his own exposure, began cooperating. Pharaoh Vance never got the lithium. The settlement included a permanent injunction barring any future extraction attempt on the 6 properties without direct, individually negotiated agreement with each landowner, negotiated, this time, from a position of overwhelming strength. Walter Hobbs stood on his porch the morning after the verdict came down, and for the first time in months, his hands were steady. Elena stayed the whole summer that year. She fixed the fence by the east field. She learned, again, how to drive the tractor. In the evenings, her grandfather would sit beside her on the porch steps and tell her, again, the story of 1911, of the man who first cleared that land, of the clause he had insisted his lawyer include, a clause he likely never imagined his great-granddaughter would use, 113 years later, to bring down a company worth $11 billion. He always said, Walter told her, that the land remembers who it belongs to. Elena never went back to the city firm. She opened a small practice 40 minutes from the farm, and within a year, her waiting room was full of families who had received the same folder, the same smiling representative, the same quiet thread dressed up as paperwork. She kept a copy of the 1911 statute framed on her office wall, not because it was rare, but because it was proof of something she believed completely, that the biggest company in the world could be brought to its knees by one family, one law, and one person who refused to stop reading until she found it. Every new client who walked through her door, clutching a folder they didn't understand, heard the same words her grandfather once told her, read every page twice, and never sign out of fear. The end.